You need to know this. Another day, another Supreme Court decision in favor of big money in our politics. Yesterday, in another 5-4 ruling, the right wing of the Supreme Court struck down an Arizona law that provides public financing of elections. The law was intended to level the playing field between people with huge fortunes and rich friends and just average folks running for office by supplying matching public funds to candidates who are being outspent by private money. The law made sure that electoral politics in Arizona wasn't a whoever has the most money wins sort of game. The High Court ruled that any attempt by the government to equalize electoral opportunities, as in making sure both candidates are on a level playing field financially, is unconstitutional. But what is constitutional to this conservative Supreme Court nowadays is a pretty good question. The corporate takeover of our democracy, as decided last year in the Citizens United case, makes that point. So how does this really make sense? Isn't fewer and not more corruptive corporate dollars in our elections a good thing? And did the Supreme Court just kill off public financing of elections? Here to offer his take on the issue is Sean Parnell, president of the Center for Competitive Politics. Sean, welcome.
Thank you for having me, Tom.
Great to have you here with us. Why do you hate democracy?
I don't. I love democracy. I also love free speech. Simply put, the government has no role in deciding how much political speech should be in the campaign process. They should not be deciding when a candidate has spoken too much or too little. That's up for candidates. That's up for their supporters. That's for voters to decide.
We're not talking about speech here. We're talking about money.
Well, money enables speech.
So you're going along with the Boston versus Vallejo, or actually arguably the Buckley versus Vallejo decision of the Supreme Court that money and speech are the same thing. I don't think that the founders ever would have thought that. I mean, Jefferson warned about the danger of overblown influence of wealth. Madison warned about it. Hamilton talked about it twice, the Federalist Papers. This is a pretty radical and fairly modern concept that the Supreme Court has brought us.
No, actually it's not. I mean, Buckley v. Vallejo has for 35 years been the defining case
35
in
years
terms
is pretty modern.
Well,
that's my point. I mean, this is not something that the founders ever would have imagined.
Well, before Buckley, though, there was not a broad attempt to limit the ability of citizens to contribute to candidates and causes of their choice.
There were a number of them. There were in virtually every state there were laws about how much money could be spent in elections. And in 1907, you had the Tillman Act that said corporations can't participate in federal elections or in any election at all in any way.
Well, there were some laws, but certainly not to the extent that there was after Watergate. That really triggered a rush to campaign finance regulation.
The anti-corruption laws.
Some of them are anti-corruption, some of them are pro-incumbent, some of them are designed to stifle unwelcome speech.
But just because the Supreme Court says something is right or is true doesn't mean it is. I mean, the Supreme Court said in Dred Scott that slaves were property, and the Supreme Court said in 1889 in what was the case? Anyway, separate but equal. Plessy versus Ferguson.
Sure,
the Supreme Court has said a lot of stupid things over the years.
I'm very happy to hear that you're not stuck on precedent. A lot of people, when Citizens United came out, were absolutely hysterical over the idea that the Supreme Court had overturned what turned out to only be a 20-year-old precedent. So I'm very glad that you're not one of those people.
Well, they overturned the Tillman Act from 1907.
No, they did not. The Tillman Act was not overturned.
How so?
Because the
Tillman Act was specific to a campaign.
The Tillman Act concerned campaign contributions to candidates.
Well, my point would be, frankly, I mean, if you want to get here in the wonky weeds, and we'll just stay there for 30 seconds because people's eyes will glaze over, is I think, that the decision that was wrongly decided was Marbury versus Madison. I think the whole concept of judicial review should not exist. It's not in the Constitution. But that's where me and Phyllis Schlafly agree, and we'll just, but shouldn't, let's assume tomorrow that McCain-Feingold was back in place, or that all across the nation, states like, laws like Arizona had, like Maine had, like Portland, Oregon had, where if you get enough signatures and if you can prove, in other words, you can prove that you have some basis of support among the populace, that federal funds or state funds are used to support your candidacy, and when somebody tries to outspend you because they happen to be a millionaire or a billionaire or they have buddies who are, the state will ante up to level this.
Well, again,
what possibly could be,
Because it's not the government's role to try and establish a level playing field. As the Supreme Court has said, the idea that the government can try and hold down the speech of some in order to elevate the speech of others is wholly foreign to the First Amendment.
Well, then the opposite of that is oligarchy.
No, not at all.
Certainly.
What you're not seeing is that there is a lot of money in America on all sides of the political spectrum, unless you're truly talking some fringe ideas, you know, restoration of the monarchy and that sort of thing. The Democrats don't have a problem raising money. Republicans don't have a problem raising money. People who have ideas all across the political spectrum are able to raise money, and one of the things that actually limits that is campaign
But why should money be the defining thing? I mean, you know, why not like all the other, not all of the other, but most of the other OECD nations, certainly most of the EU nations, say money is not speech.
Well, because
speech is speech.
We have a First Amendment, and the
First Amendment does not say money is speech.
No, it does not. But the important thing to remember is that money enables speech. If that holds true whether you want to take $100 down to Kinko's.
Getting a bunch of people to go to support you enables speech. Getting a bunch of supporters enables speech.
There are lots of things.
Getting in front of the media enables speech. All of that can be done without money.
Actually, not very effectively. Without money to enable you to convey your message,
well, what
you're
if we
really
ban
not
political
able,
advertising? Like we ban tobacco advertising?
That would certainly be a violation of the First Amendment. I mean, candidates have a right to distribute their message to the public.
I agree with you that it would be a violation of the First Amendment.
Well, but actually, what you were arguing for would allow the banning of political ads, because you could ban spending money to
so how do we prevent?
We
just have 20 seconds left. How do we prevent this nation from becoming a nation where only the rich or the friends of the rich have political office?
Well, we don't have that system right now, and we're not heading in that direction. There are candidates all over the country who do not have great personal wealth, who are running for office, who are winning, who are able to
few and far between having their friends. But Sean, we'll have to leave it at that.
All right. Thank you, Tom.
Thank you for dropping by. Thanks for this most recent ruling. Look for even more corporate-owned candidates to spring up. That means more people who deny global warming, more war hawks, more shills for Wall Street billionaires. We'll have more on this radical Supreme Court in tonight's Daily Take.